All right, Crim 4, let's get this Chapter 5 knocked out. Chapter 5 is going to talk about the privilege against compulsory self-incrimination. So I'm going to be willing to bet that you've heard the phrase, I plead the fifth. I plead the fifth, I plead the fifth, I plead the fifth. You've heard that before when people don't want to say something that might incriminate them. That's basically what we're going to talk about throughout this chapter. So, should a defendant be compelled or forced to testify in a criminal case? Ultimately, the question here is, should they be forced to testify or tell on themselves, incriminate themselves in court? And per our Constitution, the answer to that question is no. We have the right to refuse to testify against ourselves or incriminate ourselves in criminal court. And we're going to get into the real specifics of that in this chapter. So there are four parts to this privilege. First and foremost, that compulsion or the entity forcing you to testify must be the government. It can't be your employer. It can't be the bouncer at a club. It has to be the government, meaning an official like a person, law enforcement, or the courts. Okay, so that's the first part. They are only talking about, number two, you being forced to be a witness against yourself. You testifying against yourself. You making yourself guilty in a court of law of committing a criminal act. Number three, this privilege refers to criminal cases only. So when we're talking about pleading the fifth, if you're sued in a civil court where the punishment is not your freedom but only money, if you are convicted in a civil court, typically your punishment will be to pay fines or large amounts of money. In a criminal court, the punishment is typically your freedom. So the privilege against self-incrimination only exists in a criminal matter, and it has to be testimonial. So when you hear the word testimony, what do you think of? Testimony are spoken words in court. Spoken words. So this does not necessarily, it can, but does not necessarily refer to documents. So testimonial evidence. Evidence is not necessarily protected by this privilege unless it is testimonial in nature. Again, written evidence against you. If you wrote in your diary 2 months ago, I'm going to kill so-and-so, and then you killed that person, and then someone found your diary, and you had already written in there, I'm going to kill so-and-so, that's not testimony. That's written evidence. One test for whether or not a statement is testimonial is whether it can be true or false. Okay, so documents. I'm probably not going to ask you a lot about this, so I'm going to kind of skim over some of this stuff, but there are some cases that are listed in your book. There was that early case, Boyd versus the United States, where the court held that a subpoena given to obtain private records of an individual violates the Fifth Amendment. But later cases hold that if the documents were pre-existing at the time the subpoena was issued, it is not a violation of the Fifth Amendment. For example, again now, Fisher versus the United States, Supreme Court held that contents of an existing document are not protected by the Fifth Amendment since the preparations of those documents were not compelled by the government. So again, go back to, I wrote something 2 months before I killed somebody. Did the government make me write that statement against myself? No. If the government made me write that statement, then they can't use it against me. If I wrote it of my own free will, they can use it against me. Make sense? I know it gets a little bit complicated. So we're not going to delve super deep into this in the quizzes, but I want to make sure that we kind of understand. Then California versus Byers. California court required. This is a case where interesting, because you know that if you get in an accident, you are required to leave your insurance information with someone. So if you hit somebody, or if you're in an accident of any sort, you have to give your contact information and insurance information. So that's kind of a little bit of an exception of the privilege against self-incrimination, although you're not necessarily incriminating yourself by leaving your contact information. You're not saying, I hit you, so here's my contact information. You're saying there was an accident and here's my contact information. But anyways, okay. So Broswell. So Broswell was a case where Broswell actually owned a business, and the court ordered Broswell to provide documents regarding the business in court. But Broswell said, if I provide you with these documents regarding my business, I'm going to incriminate myself. And the court said, too bad, so sad, Broswell. We're asking for these business documents, not specifically your documents. So because they're regarding the business, you still have to turn them over. And Curcio was almost the exact opposite. Curcio said, well, if I testify, and this was oral testimony or verbal testimony, as to what I did on behalf of my company, I'm going to incriminate myself. And the court said, you're right, so you don't have to testify. So to be honest with you, there's a lot of mixed messages that you get in all of these, these different cases. So when you get a minute, hopefully you are reading along in the book. This is chapter 5. They really have some pretty interesting cases. And again, like I said before, these refer to criminal cases only. This case was an interesting one, and I think it's interesting because it refers to a probation violation, probation revocation hearing. So probation revocation hearings are considered administrative hearings as opposed to criminal hearings. So the probation officer filed a violation of probation against this Conti guy, and he was trying to fight the violation in court, and he was being forced to testify. So if he testified on the record in this court case, which was considered administrative, what they were going to do was take that testimony and use it against him in an additional later criminal case. Again, kind of complicated. If you read through it in the book, I think it might make a little bit more sense. If you do not assert your rights against self-incrimination in court, you lose those rights. Let me say it again. If you don't assert those rights, if you go on the record in court and your lawyer doesn't tell you to stop talking, you lose those rights. It is your responsibility to say, I plead the fifth. Failure to assert those privileges results in those privileges being lost, and that's what they're referring to in this case here. We also talked about the voluntariness test. We've talked about all of these cases before. These are all cases where police did shady things to get people to make confessions. Okay, so this portion here, it is on page 116 and 117 in your book. Talks about substantive and procedural due process tests. I'm going to kind of skip over it because I'm not going to ask you about this, and it starts to get, again, a little bit more complicated than I think we absolutely positively need for this particular class. But again, when we are talking about the right against self-incrimination, Miranda is still going to be that case that we talk about, and we is kind of that controlling case that controls everything about you have the right to remain silent. You have the right to refuse to answer questions. You do not have to testify against yourself. You don't have to tell the police or a court all the things that you have done. And that also, all of those rights definitely have a place in the whole interrogation process. Confessions taken after lengthy interrogations have also been considered violations of the of due process and violations of voluntariness. These two cases here, and they both involve different shady techniques that were used by police. In the Beckwith case, I believe this is a case where officers tried to be ultra sympathetic with the defendant to try to get him to confess. And then in the Brom case, the officers ultimately used some sort of threats to get the defendant to confess. And then again, we go back to Miranda, and we talked about Miranda in a previous PowerPoint presentation. And this is a case where the defendant claimed he did not know that he did not have to speak with the police officers. So while he was being interviewed by police, he told them the whole story. He told them everything that he did. And after he confessed to raping and murdering a woman, he talked to his attorney, and his attorney's like, "Why the heck did you tell him all this?" And he's like, "Well, they told me I had to." And the attorney said, "You didn't have to talk to them at all." And he said, "Well, I didn't know that." So can it be, what's the word I'm looking for? Intimidating if you are in police custody and police officers are interrogating you? Of course it is. It's a nerve-wracking, uncomfortable, scary, you name it type of situation with a lot of pressure placed on defendants. So you can only imagine what that feels like. So now, because of that whole scenario in that one case, officers are now to tell them you have the right to remain silent. Anything you say can and will be used against you in court. You have the right to consult with a lawyer, and you have the right to have a lawyer present during any questioning. If you cannot afford an attorney, one will be appointed for you free of charge. Would you like to speak with me now? Officers have to get that waiver too. They have to get that waiver now. So the Supreme Court has agreed and continued to agree that people cannot be forced to speak against themselves. So again, back to Miranda, officers have to be able to prove that the suspect was adequately and effectively advised of their rights, and that the exercise of those rights were fully honored by the police. So I can't remember if I talked about this last time I lectured on Miranda, but my partner over at Hoover High School, every single time he arrested anyone, no matter who it was, he pulled out a Miranda card from his left front pocket. And it was a laminated card, and he would get it out every time. He would pull it out, and he would read word for word his Miranda card from his left front pocket. And I didn't think to myself, why does he do that? Because I think I kind of knew why he did it. Do you think after 25 years being a police officer, he knew front, back, up, down, word for word, everything that was on that card? Of course he did. Why do you think he did that? He did that because it was a habit, and it was something that he could absolutely positively say, I did read him his Miranda rights because I do it every time Without fail, no matter what, it is absolutely positively part of my routine. Me being the probation officer, I worked in the same, we shared an office together for years. Every single time he did the exact same thing. So, and he read it word for word, and it also had the final phrase at the end on their cards with Fresno PD said, "Do you understand your rights and do you wish to speak to me?" Those two things round out the whole Miranda warning, because if you don't get the "Do you understand your rights?" Yes, I understand my rights. "Do you want to speak to me?" Yes, I want to speak to you. You have to get the "Do you understand?" and "Do you want to talk to me?" If you don't get those last two things, then you don't have a waiver. Does that make sense? I hope it does. So ridiculously important. You do not want to be the officer that loses a significant case or gets a case tossed because you didn't read them their Miranda rights, or because you were sloppy, or because you can't remember if you did or not. I think I did. For this officer, Officer Underwood, he was every single time. There was never a doubt. Never a doubt, because that's what he did every single time. What do you do if someone doesn't speak English? Do you flip it over and read the side in Spanish if you don't speak Spanish? No, not a really good idea, because what if they have questions? You wait till you get an interpreter. Don't question them if there's any question. If you've got some questions as to whether or not this person can understand you, or whether this person is extremely drunk or is extremely high, question them later. You always want to make sure that your arrests are going to be clean. You want a clean arrest. Trust me, it's not worth going through the drama of having to deal with it later. So, when is Miranda required? Miranda is required when an individual is in custody or feels they are not free to go. Okay. Does this mean they have to have handcuffs on? No, it does not mean they have to have handcuffs on. It means they feel they are not free to go and they are being questioned. And let me tell you this, my favorite Miranda story. A young man happened at Hoover. He came at a girl, and Superman jumped, fly through the air, punched this girl right in the face. I mean, rocked her. It was awful. It was horrible, horrible. There were 2 or 3 campus security officers that witnessed it. Plus, there was videotape, and the victim and the suspect admitted it. So the officer handcuffed the kid, brought him into our office, the police probation office, and, got his information. And we get him in the car. He's in the back seat of the car. We have not Mirandized him, okay? Nobody read him his Miranda rights at this point. And thinking about it right now, is there a pretty good case against this kid? Probably. We've got video. We've got witnesses. We've got the girl with the bloody face. It's a pretty good case. Okay, so he's in the back of the police car in handcuffs, and I'm in the front of the car with the police officer, and we're driving him down to juvenile hall at this point. And I look back at him, and it's August in Fresno, and it's really hot. And I look back at him and I say, "Can you feel the air conditioner?" And he says, "Yeah." And I said, "Okay, good." And then he says, "The bitch deserved it." Is there a problem with Miranda? And I'm going to tell you the answer is no. Did I ask him any questions? Did anyone ask him any questions about why he hit her? Or if he hit her? No. Okay. Again, if you're going to talk to somebody, you probably should Mirandize them. But nobody had to Mirandize him. We weren't going to question him. There was no need. We had a slam dunk case on this one. There was no need to ask the kid any questions. But in custody, or they feel they are not free to go, which doesn't necessarily mean handcuffs, and questions or interrogation, however you want to, and I will probably ask that on a quiz. Those are the 2 things that have to happen. There are public safety exceptions. Imagine someone is running through a schoolyard. He's got an assault rifle, and he ditches it somewhere on school grounds, and then you find the guy without the gun half a block away, can you ask him where the gun is that he just ditched on school grounds? Yes, you can, because that's a public safety issue, and you don't want a little kid to pick up the assault rifle. So it's got to be some pretty extreme circumstances, but they are probably pretty few and far between. But there are some exceptions, and sometimes undercover stings and stuff like that. You can probably work around Miranda, but not usually. And typically for the Sixth Amendment right to counsel during interrogations, basically anytime you are at risk of losing your freedom, you have the right to have an attorney. All right? So any time that you are at risk of losing your freedom, you have the right to have an attorney. Okay? And that it starts with as soon as you're being questioned by police. It is on the burden to prove that a person has waived their rights to Miranda is on the government. So the police officers will typically, that's their first line they write typically in a police report is, on such and such date at such and such time, I notified such and such of his Miranda rights per my department issued Miranda card, and he knowingly and voluntarily waived his rights. A lot of agencies or officers will go so far as to have them sign a document saying they agree to waive their rights. So here's a summary. Fifth Amendment, protection against self-incrimination. Only in criminal court. There are limitations with testimonial evidence. Miranda, and